Is there a way for, I guess, a veteran to reopen the claims after missing that first appeal deadline, or is it pretty much, the path toward what we would consider reopening would be like a supplemental claim?
Typically, it would be a supplemental claim. There are a couple of exceptions, but I hesitate to even toss these out because they're so rare, but there are a couple. One exception is if the VA initially turned down the claim because they didn't have military records, and you have told them there are military records that exist about the claim, but they didn't get them, and you later get them, and those records show that they should have come to a different result. That's the tricky piece. You have to have records that actually show that something they decided was wrong, that they would have known was wrong if they'd had the records. If you can show that, then under 38 CFR 3.156C, they're supposed to go back and give you the date of the original claim that they denied once they get these new records that show they got it wrong the first time.
And I'm smiling because we just spent quite a bit of time at the recent National Organization of Veterans Advocates conference discussing just that provision.
Yep.
And one case that had gone all the way up to the Court of Appeals for Veterans Claims.
Yep, that case was argued. Interesting argument.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Welcome to Victory Over VA. If you're a veteran struggling with the VA's disability system, or just want to make sure you're getting the benefits you've earned, you're in the right place. Don't forget to hit subscribe so you never miss an update that could change your life. I'm Kristian Terison, here with renowned veterans disability attorney Francis Jackson of Jackson and MacNichol. Jack has dedicated his career to helping veterans like you win the benefits you deserve, recovering millions of dollars for thousands of heroes. But this podcast isn't just for veterans navigating the system. It's for their families, their friends, and anyone else who wants to stand shoulder to shoulder with those who served. So stick around because we're here to make sure you get the support you need. Today's episode is on clarifying appeal deadlines. Anybody who's ever looked into the VA disability claim system knows that there are about as many deadlines as there are medical conditions you can claim disability for. So to begin with,
but fewer than there used to be.
Fewer than there used to be, it's true, and we'll get to that. But just as a preliminary background matter, why are VA deadlines so important?
Well, VA deadlines are important because they control whether or not you will be able to get an extended period of back benefits when your claim is granted. That's the critical point.
And what happens if a veteran misses a deadline in the process?
Usually, that's going to mean you have to start over and you're going to lose the potential period of past due benefits. The flip side is if you keep these things in appeal, even if it takes a long time, the VA will faithfully pay all the way back to the beginning if you win your claim and establish that as the onset date. So we've had people who have won more than $500,000 because their claims dragged on for so long. I don't encourage people to have claims that drag on, but if you do, as long as you're careful about the appeal deadlines and you're consistently hitting those deadlines, then you have the potential for getting benefits all the way back to the beginning.
So talking about the changes in deadlines, so folks with claims that have been pending since before the Appeals Modernization Act went into effect, they're under the legacy, what we call the legacy system.
That's right.
And then there's the Appeals Modernization Act, or AMA system.
Yep.
What are the key deadline differences there?
Well, in the legacy system, the VA would issue a decision. Once they issued the decision, you needed to file a notice of disagreement, and you needed to get a kind of a second level decision issued in the form of a statement of the case. Once the statement of the case issued, you only had 60 days in which to file a Form 9 appealing that to the board. The legacy system didn't allow things like higher level review and supplemental claim, which were created by the new AMA system. So the narrowest deadline there was that statement of the case to Form 9 deadline of 60 days. Now, in the current system, under the Appeals Modernization Act, or AMA, basically the deadlines, with the exception of the court, are all a year, one year.
Okay, so if a veteran is applying now and they receive a decision they disagree with, they have 1 year, and it's 1 year from the date on the decision or receipt of the decision?
It's 1 year from the date of the cover letter of the decision.
Okay.
And sometimes that makes a difference. We have seen cases where the decision was substantially earlier than the cover. Usually it's the same day or within a day or two, but once in a while you'll see one where there's a real gap between the date on the decision itself and the date on the cover letter. But the cover letter is the critical date.
Okay. And you had mentioned before that, if a veteran misses an appeal deadline, the usual process is just starting over. So
Yeah.
if a veteran files nothing within that 1 year after receiving their initial decision, essentially they would lose that effective date possibility, which would be whenever they first applied.
That's right.
And are there any other consequences? Or is it pretty much limited to the effective date?
Well, there are consequences. If you fail to appeal within that 1 year period, not only do you have to file again, but typically you would have to file a supplemental claim. And the significance of having to file a supplemental claim is that you have to submit new and relevant evidence with it. So there's a kind of a higher burden, if you will, in addition to losing out on the potential back benefits.
Okay, so just reapplying with the same evidence wouldn't be sufficient for that supplemental claim?
No, typically what would happen is you would get a notice from the VA saying, you haven't supplied us with new and relevant evidence, so we're not going forward with this claim.
Is there a way for, I guess, a veteran to reopen the claims after missing that first appeal deadline, or is it pretty much, the path toward what we would consider reopening would be like a supplemental claim?
Typically it would be a supplemental claim. There are a couple of exceptions, but I hesitate to even toss these out because they're so rare, but there are a couple. One exception is if the VA initially turned down the claim because they didn't have military records, and you have told them there are military records that exist about the claim, but they didn't get them, and you later get them, and those records show that they should have come to a different result. That's the tricky piece. You have to have records that actually show that something they decided was wrong, that they would have known was wrong if they'd had the records. If you can show that, then under 38 CFR 3.156C, they're supposed to go back and give you the date of the original claim that they denied once they get these new records that show they got it wrong the first time.
And I'm smiling because we just spent quite a bit of time at the recent National Organization of Veterans Advocates conference discussing just that provision.
Yep.
And one case that had gone all the way up to the Court of Appeals for Veterans Claims.
Yep, that case was argued. Interesting argument.
Yeah. So for a veteran who's looking at higher level review, I know that generally higher level review is an option best suited to a pretty obvious mistake. So something where the VA failed to look at medical records, consider medical records that have been submitted, or made a factual error in, something like service dates, something of that nature. So how long does a veteran have to request higher level review? Is it that same
It's that
time
same 1
period?
year.
Okay.
And let me just go back for a second and add the other exception to the deadline that occurs sometimes is something called clear and unmistakable error, CUE, under 3.105. But you really don't want to be going down that path. It's incredibly difficult. So hit the deadline.
Yes. What constitutes clear and unmistakable and error is a very, very high bar.
It is.
And actually in all the cases I've worked on, I know we've had some successful Q claims as a firm, but I personally have never gotten a situation where there's been a clear and unmistakable error.
We've won a couple, but boy, that's a tough road. I try not to go down that road.
So for the veteran who's chosen higher level review, once they get a decision there, if they want to appeal the higher level review decision, is the deadline for appealing that another year, or?
Yes, it's still another year, but the options aren't quite the same. If you get a higher level review decision, you cannot ask for another higher level review. So your options get narrowed from 3 to 2. You have to choose supplemental claim or an appeal to the board.
Okay. But that, as you mentioned earlier, but just to make it clear for our viewers, that keeps the early effective date in play.
It does.
You go to HLR, you get denied, you appeal to supplemental or to the board,
Yep.
You're still looking at an effective date, so getting paid all the way back to
Yep.
the day
And you still have a year from the date of the HLR decision to file.
And so with the supplemental claim, you mentioned the requirement of new and relevant evidence, but again, that's just the 1 year.
Yep.
And then when a decision is received there, is it essentially similar to higher level review? You have another year, but is the only recourse from a supplemental claim decision that the veteran wants to appeal to go to the board, rather?
Well, not necessarily. I mean, theoretically, you can file successive supplemental claims, but keep in mind that you have to come up with new and relevant evidence every time. So at some point, it's not practical to find more new and relevant evidence. Typically, the progression would be, if you're denied on a supplemental claim, you probably need, at that point, to appeal to the Board of Veterans' Appeals, either in the evidence lane or in the hearing lane. Now, you actually have 3 choices. You can have what's called direct review, meaning you just ask the board to look at what's already in the record. You don't give them any more information. You can submit an argument if you want, but about why they got it wrong at the regional office. But generally speaking, if you got denied, it's going to require some new evidence to win the case. So in all probability, you want to be in either the evidence submission lane, which allows you to submit new evidence but doesn't require a hearing, or in the hearing lane, which allows you to submit new evidence and allows you a hearing. Typically, those are the practical steps once you've had a denial on a supplemental claim, unless you can find yet new and relevant evidence that you haven't submitted.
Okay. And so sort of all things, practically speaking, end with the board. If a veteran believes in their claim and believes the VA is just getting it wrong time and again, to preserve that earlier effective date, while you could choose to go around the merry-go-round of successive supplemental claims, meeting that new and relevant evidence standard every time is, you can only
challenge,
you can only say, it's my back so many times before
Before you've said it.
Before you've said it.
Yeah.
So at the board, once a veteran's received a decision there, if they want to appeal the board's decision, is there any difference whether that is a direct evidence or hearing decision?
No, the appeal options don't change, regardless of which lane you're in. But when you decide to appeal a board decision, you have 2 options at that level. You can file yet another supplemental claim if you have yet more new and relevant evidence, or you can appeal to the Court of Appeals for Veterans Claims in Washington. Now, the appeal time on the supplemental claim stays the same. It's still a year. If there's an adverse board decision, you can file a supplemental claim within a year on the same issues, essentially. Or you can appeal to the court if you think there's a legal error or a factual error that's within the scope of what the court can review. And for that, you only have 120 days. That's the deadline at the court, although there's a special provision that essentially allows another 30 days if you have a good reason for being beyond the 120 days. So it's a little bit squishy, but think in terms of there's 120 days and you'll be safe.
Yes, if there's anything I've learned from dealing with the VA, it's don't rely on their generosity if you don't have to.
Yes.
And for the 120-day deadline, that's just for the Court of Appeals for
That is
Veterans
just for the
Claims.
Court of
So the
Appeals.
supplemental
Still a year.
is still a year. And does that, it's a regular supplemental claim, so it would be back at the regional office with the new and relevant evidence.
That's right.
Okay. So we're almost out of time for this week, but I wanted to ask, what's your best advice for veterans or those working or supporting veterans with a claim if they're worried about cutting it close on a deadline?
Well, you can always file an intent to file form, which acts as a placeholder. And off the top of my head, I think that's form 210996, but it's easy enough to find on the internet. But if you file an intent to file, that kind of stops the clock, if you will, and gives you up to a year in which to actually complete and file the claim.
Okay, so even for somebody who's running up against a year deadline, they could effectively double it by getting that intent to file in time.
Yep, that's right.
All right. And on that hopeful note, that's all we have for this week's episode of Victory Over VA. Please be sure to like and subscribe and join us again next week.
We look forward to seeing you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.